I mean, I'm thinking of those incidents that are well documented during the 50s and 60s when African Americans attempted to register to vote, and they were simply told, they were given these ridiculously difficult tests that they had to take, and if they failed those tests that they were set up to fail, they couldn't register to vote. And when asked why they weren't allowing African Americans to vote, the white registry staff would simply say, well, they just didn't pass the test. They never admitted that they were being racist. So we're relying on admission of racism to uphold the law.
That's right. And of course, in today's world, no one's going to say or admit or even sometimes believe that they're involved in racist acts. Think about the climate. How many people would say, I'm getting up today and I'm going to deliberately try to warm up the climate or cause climate change? That's whether we're trying to make the climate change or hotter or chaotic is almost irrelevant. The question is, are we? And if we are, we should act to do something about it. Similarly, if we're stratifying society in a racially segregated way, if we're denying people access to full participation as members of society, it's irrelevant whether we intended for that to happen. And it's not a new body of law. This law has been in place since the 1960s. And it's not just in housing, it's also in voting, as you suggested, it's also in employment. So the court is really on a very disturbing trend to really turn back the clock to the early 1950s.
Now, under existing law, under the Fair Housing Act of 1968, as it's written, can't institutions already show some kind of, if they do have a real justification and can prove it, that they are still allowed under existing law to, do something that might have racist outcomes, as long as they can prove that there's a good reason?
Yes, so basically, and this comes out of Title VII, and which is fair employment, and Title VIII is fair housing. And the courts developed this structure, which is that if you have a disparate impact, and the party causing that disparate impact can state a legitimate reason, and no other reason that could achieve that same outcome, then then the disparate impact is okay. So when you have a discriminatory impact, it doesn't automatically mean that the party suing to overturn that impact win. The defendant can say, this is the only way I can build housing, and there's a crisis to build housing, and there's no other way of doing this. And if they can show all that, then they win. And again, it's important this is both in employment and in housing and other areas. And this has been in place for over 40 years. And, the sky hasn't fallen. And in fact, even with disparate impact, the country still remains highly racially and economically segregated. So in many ways, it doesn't go far enough.